Welcome back to Tennessee Mornings. The EEOC has posted the most common filed employment complaint for the last year, and it is retaliation. Someone complains about something they believe is illegal at work, and they get punished for it. Joining us now to explain is Legal Eagle, Jim Higgins. Good to see you, Jim.
Good to see you.
This is pretty common, isn't it? I mean, you see this quite a bit. Why is retaliation so common?
You know, I don't know. I don't know why it's so common, but it's true. In our office, in our employment law section, the two we have more of every year, in and out, is retaliation and failure to pay overtime. And they are, to me, they're both ones that are easy to avoid, but for some reason, employers just seem to flock to them. We always have more of those than anything. And, you know, I've tried to figure it out a little bit. I don't know if it's human nature, that people just don't like being questioned, that people, you know, feel that someone's, get defensive automatically, overreact. I don't know. But, you know, what's interesting is so many of the retaliations cases that we have had that have ended up being pretty big cases, the initial thing that was complained about sometimes was nothing. So what happens is someone will come in and say, hey, you know what? I think I'm being treated differently because I'm a woman or because of my race or whatever. And it may be a misunderstanding. There may be nothing there. But there's this overreaction, and that person has what we call an adverse employment action. They move them to a different section, a less favorable job. Their pay goes down a little bit. Wow. And all of a sudden, even though there was no initial problem, now we have a problem because they've been treated badly, because they brought up a question about how they were being treated.
So what's an employee to do?
Well, you know, I think if a couple of things would happen on either side, these cases could be avoided. And one of it is they just really need to take time. I mean, that knee-jerk reaction, immediately do something, sometimes that can be just too quick. Do a proper investigation. Document. You know, so many times in these cases, the person with good documentation wins. And that can be as simple as emails. You know, we've talked about that where my clients say, what should I do? I say, whatever you do, follow it up with an email. You know, it doesn't have to be adversarial, but say, hey, this is confirming that you're looking into it and making sure everything's okay. And that way, if it does end up bad and we're all arguing about it in a courtroom a year later, my client says, I did that, and here's the email.
So what should an employer do then to avoid this?
I think it's the same on both sides. You have a file. The employer, before any of this ever starts happening, one thing they can really do to help is to have a policy. This is what we do when a complaint is filed, and then follow that policy. And then if you can they can come to a courtroom and say, hey, this is what we do, everybody knew it, here's our policy, and this is what we do every time, and we're consistent, and we think this is fair, and this is what we did in this case. And if they can show they follow that policy routinely, that can be a great defense in these cases. All right, well, if you have any legal questions, you can certainly contact Jim, and here's how you do it. The Higgins Firm, located here at 353-0930. You can also contact him personally through email, jsh@higginsfirm.com. Thank you, Jim. Appreciate it. Thank you,
Good to see you.
Good to see you.
All right.